All right. Well, good morning, good afternoon, and welcome back to the Money Advantage podcast. I guess it depends on where you are in the world. Today we are talking about beyond ILITs, and we have returning guest Andrew Howell with us today, and we're really excited to have this conversation because Andrew has been doing estate planning for quite some time and really brings a perspective for serving people in a way that allows them to do estate tax planning and also legacy preservation from a high net worth family perspective. And Andrew, we're really excited to have you join us again for this conversation today.
It's always an honor to be on your show, you guys. Anytime you want me to talk, I'm happy to do it. And you had that great video that you had about islets and kind of went into those. And I think what spurred this was my ambiguous comment about there's better things to do than islets. And so I appreciate you allowing me to explain.
Well, I think this is going to be a really helpful conversation for our audience who really is in a position of wanting to do tax planning, but wanting to make sure that they also have control so that they can make decisions and have access to their capital. And a lot of people that we are talking to and are who are wanting to create a legacy for their family, they're aware of using life insurance as a key piece of that tool of accessing it for family banking and being in a position of really being able to utilize the life insurance benefit to provide a death benefit that allows you to keep this perpetual wealth going in future generations. And so, Andrew, I know that working with life insurance as a part of estate tax transfer and estate tax planning is a really key piece of your philosophy and the foundation that you do in a lot of your work as well. And so I'm really excited to have you join us for this specific conversation. And I love that you want to share pros and cons and really help people to see a better way than just going straight to the ILIT strategy on a regular basis.
Yeah, life insurance. I mean, I'm probably preaching to the choir with a lot of the audience here, but it's such a powerful tool, and it's not just how it used to be done in the old days, where you're just insuring your life, which is an important part of it. Don't get me wrong, right? But you can do so much more. And again, preaching to the choir. In fact, I've been a life insurance agent longer than I've been a lawyer. I got my life and health certification in 1996, and I think the top three hated professions in the world are lawyers, insurance agents, and used car salesmen, right? So two out of the top three. But I don't sell policies at all, but I keep it active because it's so important. And ILITs, Irrevocable Life Insurance Trust, we always have these acronyms for our trusts that we use, are a very powerful tool, and they used to be used a whole lot. In all honesty, this is true, I have not started a new ILIT for a client in 12 years. And it's just because of all of the drawbacks. You brought some of those up on the webinar that you had done on them. And I just think there's a better way. And so what I thought we could kind of do is just lay the foundation of that. As you guys know, I love to use whiteboards, just maybe kind of walk you through pros, cons of islets. What are the negatives that I see beyond probably some of the ones that you had touched on from your angle, from a legal perspective, and then also how am I doing it for clients? And I'll just be real open with you and probably give more information than I should. But again,
Yeah.
it's a different problem for the clients that have to worry about an islet. Because if you're worrying about an islet, you're worried about estate taxes. Because that's in my mind, that's kind of the only benefit. But why don't we just dive into it? I thought maybe I'll share my screen, kind
Well,
of go
well,
through this.
yeah, before we dive into it, I'd like to set the stage a little bit because I know there's
Yeah,
going to be
please.
some people are going to tune in, whether live right now or later on. They're going to start listening. They're going to go, well, this is never going to pertain to me, so I'm going to stop listening. But I'd like to set the fact that although the federal exemption is pushing 14 million right now per person, it always hasn't been like that. And as recently as the George Bush administration, it's been 1 million. And there's a lot of them of Americans now that will fall into that category. So this is why, and also we're going to have the great transfer of wealth from the baby boom generation that is estimated to be anywhere, but I've seen estimated as, as um, as low as 13 trillion. I don't know if I've ever said that in a statement before.
Try
To as
90,
yeah, to
90.
yeah, to as high as 90
Yeah, no,
trillion dollars.
you guys we're all simpatico in how we think about this and this wealth transfer that, in my opinion, is almost entirely unharnessed. Most people never do any estate planning in the first place, and they don't put much thought about the impact that that money is going to make. And that's definitely something that we're going to talk about. I mean, I think that, in fact, I have a whole nother presentation that I'd love to do for you guys on this because it fits right within, seven generations of wealth and all that kind of stuff and our philosophies within Trusted, which is there's really four erosive effects of generational wealth. Why doesn't it make it to the third generation, right? All those adages. And it's really three things. Number one is the division of the estate, right? You take a husband and wife, they're worth $100 million. They have four children who have four children who have four children. Every great grandchild's getting 1.5 million. That's still a lot of money, and that might buy a phone call sometime in the future, right? It's just not as much as it used to be. So you don't want to divide assets. This idea of families not doing business together, that's ridiculous, right? I mean, name a wealthy family out there that doesn't keep businesses together. You don't see the Rothschilds, the Rockefellers, they're not breaking up their family companies. Yeah, the ownership is diffused, but not dividing the power. That's one. And then estate taxes, right? What you're going over, Bruce. Absolutely. I mean, that's what's governing an island. Why would you do one? Because if you're not worried about estate taxes, you definitely wouldn't do an island. And where people are saying right now, under the Trump tax reform, you have 13.99 million of credit against this tax. So as a married couple, that's just south of 28 million. 27.98 million. They didn't make it 28 million because I wasn't a math major and I think the IRS has tried to torture me, but it's 27.98 million and most people don't have $28 million net worths. Now, of course, you got to say, okay, what about that death benefit? And what will be included? Would it be the value of the policy? And then when spouse one passes away and they leave the death benefit to spouse two, well, yeah, it goes income tax free, but now they've got a pile of cash part of their estate. Now, at the end of this year, that's set to all expire. Right now, the way that that law is
Mhm.
written, January 1, it gets cut in half. Everybody will have 7 million of credit. We don't know exact numbers because it's adjusted by this inflationary index, but roughly, half, still 14 million. But, when I started practicing, the amount you could pass estate tax free was
Bruce, do you still hear him?
Yeah, we're having some tech.
Okay,
Hey, Andrew, we just
you're
had a
back.
glitch with you. So when you said when you started, what was the amount? Because there was a glitch
it
there for just a second.
Sorry, yeah, it was 600,000 per person or
Oh, wow.
1.2 million as a married couple with a 55% tax on anything over and above. And this is a political thing that is going to shift. I mean, it's shifted 16 times since I've been practicing. And I do think, I mean, if I was a betting man, which I'm not because I hate losing money, but my bet would be that the Trump tax reform in some way is going to get extended. But 4 years from now, there's a whole nother political circus. And in 2021, we were one senator away from the Trump tax reform going completely away. And some proponents out there, like Bernie Sanders, just as an example, he would like you to only be able to give 3.5 million away estate tax free with a 55 to 77% tax. We got to keep our eye on this. And so if you're out there and you have a successful company, you have real estate holdings, you have an illiquid estate, let's say, that's a whole nother problem. I mean, there's so many insidious things about the estate tax. I hate taxes in general, right? I'm a tax attorney. You pay me to hate taxes. Don't work with a tax attorney that loves taxes. But the other problem with it, functionally, it can just destroy an estate. I mean, estate taxes are owed 9 months following date of death, and they have to be paid in cash. The government does not accept real estate. They do not accept closely held business interests. So you're having to sell things within 9 months and you're not always getting the best value. So, the estate tax is a very insidious thing. It can be an incredibly erosive effect to wealth transfer, right? Every generation is taking a 50% haircut. We're losing assets, right? Erosive effect number one, again, division of the estate. We just talked through estate taxes. We'll come back to that a lot here in just a minute. The third one is having the assets taken by creditors, right? You leave assets to your kids, and then somebody comes and sue them, or they go through a divorce and it's taken. And then the fourth one, which is where, we think a lot alike, is the misuse of the assets by the beneficiaries. The
Hmm.
beneficiaries just haven't been prepared to handle what you're leaving them. And, three of those erosive effects, objectively speaking, can be solved pretty easily through legal work. And I can help solve those three first things: division, estate taxes, and creditor protection. But when it comes to how your kids are going to use the assets, that's for you to decide. And we have thoughts on how that can all happen. But no, I'm with you 100%. And I think that the kind of what I'm going to lay out for you here is very close to what I have myself. I think it really works to solve those four erosive effects on these legacies.
Andrew, I really appreciate you bringing that up because I think there's always that question of how do I really bless my kids the best? And certainly it's not by having the legacy transfer or the wealth transfer eroded, and especially not by taxes, and especially not by dividing it up and parceling it out to each individual child and each individual grandchild and each individual great grandchild. And it's also really important to ensure that they have protection from creditors, lawsuits, things like that. It's also really important to ensure that the heirs are prepared, which is a huge piece of the work that we're doing right now. I'm so glad to have you so like-minded in this conversation. And before we dive in, Bruce, was there anything else that you wanted to say just on the relevance of somebody who might be saying, I am not concerned about estate tax? I mean, I hope that you're not saying that if you've listened this far in the conversation, but Bruce, just anything else on that?
No, first of all, I just wanted to get in kind of early just to make sure that people don't turn off because what I find as an investment advisor, everybody else is wealthy, but the person you're talking to they don't think they're wealthy, you know. And I find it humorous sometimes, when a person says to me, I met with somebody a couple of weeks ago. They have $8.65 million of very liquid capital, and they're like, "Yeah, we're pretty well off, but we're not really that wealthy." And I'm like, you are in the upper, percentiles of wealth." And so a lot of people, when they don't think they're wealthy, they don't think they need to plan because they don't think it's worth planning. It actually it just floors me that people have that mindset. So that's all I wanted to get in. And then the last thing is that let's just say the federal estate tax stays at is 40% right now, right, Andrew? And so let's just say it stays like that, but you can do something to prevent that 40% happening. Well, that's a 40% return on your money. I mean, it's unbelievable. If I brought you a strategy that had zero risk in it and it got you a net 40% on your money, you're not going to listen to the strategy. I mean,
Yeah.
it's just
Well,
something that people they don't think through when they're doing this.
it's it's planning, right? I know that's so stupid, but to me, I'm a planner. I like to plan. And one of the things that I always enjoy when talking to clients the first time and we start talking through their estate and they tell me they've got a closely held business or they've got this real estate stuff. And then I don't really bring this up till later on in the conversation, but what is their overall net worth? As a tax planner, I need to know some of those things. And they always come up with a number. And I say, well, you realize you don't really know what it is. You don't know what your estate is worth, right? What's your company worth? It's worth what somebody's willing to pay you for it. The problem when somebody dies and they're trying to assess, when I say they, the enemy, the IRS, is assessing the value of that person's estate, they're going to come in and say, okay, tell us about the company. How much revenue did it have? And then they're going to put it up against some multiple by EBITDA formula. And the value that they come up with may be a whole lot more than you're thinking about because we always feel cash poor. But I know the companies that I have are wealthy companies, they're worth money, but I never feel like I have enough money in my pocket. So it's okay, with this planning and really dealing with the estate tax, we take control, right? We go and we say, okay, these are the values, and we get independent value companies and all of these, but then we present that to the IRS, and now we put them on the defensive. right? Tell us why we're wrong. We're not waiting to see what it's actually worth. So proactive planning is just such a huge part of high net worth, high income earning families, and it makes a huge difference. Yeah, 40 cents on the dollar for every dollar above the estate tax that we're saving by not having a part of your estate. And then, the other thing is insurance, and I'm sure you guys see this in as well. I'll still have a lot of insurance agents that say buy a policy simply to come up with the death benefit to pay the estate tax, right? So, okay, you're going to have a $10 million debt or estate tax bill, buy a $10 million policy. Now you've got cash to go pay it. You don't have to liquidate things. Well, go buy the policy and keep the assets, right? Not have both. Why not have the insurance death benefit as well? All right, so I think we're all preaching to the choir here.
Yeah,
So
this is
let's do
good. Go
this.
ahead and dive in.
Okay, so I'm going to start. I'm going to just change screens on you here. Um, you guys, if I've been on, I've probably done this to you before, but you're going to see the screen go black. You're going to see a river, and then you're going to just see this page that talks
Yep.
about ILIT benefits, right? In my mind, there really is one benefit, and it's to prevent the value of the policy and the death benefit from being included in your estate. Now, remember, those are two different things, right? The value of a policy, the cash value, that's not even the value. It's this interpolated reserve value, they call it. And they take into account how much cash is in the policy, but they also take into things like your life expectancy. It's easy to think about this, right? Let's say you have a $10 million policy on a 20-year-old person, and you have a $10 million policy on a 99-year-old person. If you were going to buy that policy, Rachel, which would you pay more money for? The 99-year-old, right? Because they're going to die sooner, you're going to get the insurance benefit. So when somebody's saying, what's the value of my policy? It's not just the cash value, there's a couple more functions in it. And like with me, and I'm building a lot of cash value in those policies, that could actually be large, the cash value in the policy. So whether or not that's included in the estate, but then of course the death benefit. You say, well, Andrew, death benefit isn't subject to tax, and that is absolutely true when it comes to the income tax. At least that's what the Internal Revenue Code says for now. And it's
Yeah.
said that for a long time, and it probably will because the insurance company has a lobby in Congress that makes the NRA look like a redheaded stepchild, and they kind of get what they want. But from an income tax standpoint, that's true. But if I have a $10 million policy on my life and my wife is the beneficiary, well, it goes to her tax free, but she now has 10 million of cash included in her estate, plus all of our other assets that may have gone to her. So I just want to make that clear in that function of the insurance policy. It's the cash value and the death benefit. We already kind of went through this, but just to reiterate right now, everybody's got this 13.99 million of credit against the estate tax. Married couples, that's that 27.98. But every dollar above that would be subject to, as you were saying, Bruce, the 40% tax. Now, next year it's set to go in half, and actually the tax rate goes down. This basically is what the Obama law was. And it wasn't this number under Obama, it was about 5 million, but that number gets adjusted every year by an inflationary rate. And we don't actually know if it's going to be 7 million. We're kind of anticipating it to be something like that. So that's again the conundrum. But I will say this. I truly believe that over time, the government is not going to need less money in the future. And I think that the estate tax is going to hit more people because it's actually a pretty easy political thing. I mean,
Mhm.
Republicans will generally say they don't like the estate tax, I guess depending upon who you ask. The other, side, Democrats will say they love it. But both sides know most of their constituents don't have to worry about it. The vast majority of the population is in debt, let alone having $28 million estates. And so Republicans are going, look, we want something politically speaking wise. We'll relent on the estate tax to some degree. And again, Democrats know, look, we can make a big show about how we got this tax that's going to affect the wealthy, and they're willing to give something up. So it's a pretty easy political pawn. And that's why you've seen it go back and forth so many times in the next few years. So my hope is the taxes will go down, but I'm somewhat of a realist and I believe that they will go up.
Hey,
All
Andrew.
right.
Hey, Andrew. We don't have to go deep into this, but I want to remind our listeners that there are also state estate taxes also in certain states.
Yeah, and you wouldn't be surprised that most of those are the blue states. just as you guys are, as everybody's aware, because again, this is a tax that Democrats have a tendency to favor. You'll probably hear some of my political bias break through here, but a lot of my clients become pretty conservative when it comes to tax time. But yeah, some states do, like Washington, they have a state death tax. I mean, a number of states do. They're not nearly as intrusive usually as the federal estate tax. I think the highest one is like 16 to 19%, if I remember correctly. And so it's kind of hard in those states because if you move assets out of an estate just for state tax purposes, well, that's a gift during life, so it gets carried over basis. Where if it's part of your estate at death, it would get stepped up basis. So we might move it out of their estate and say the 16% inheritance tax, but they don't get the stepped up basis and we have to pay capital gains at 20%. So you're absolutely correct 100%, but that the states that do have it, we've got to be a little bit more careful. Um, all right, so let's talk about the negatives. These are the negatives in my mind for an ILIT, right? And these are, I know, things a lot of you had gone over, Rachel, in your talk, but loss of control. Having a big, I wouldn't say there's no access to the policy benefits, but they're very, very restricted. Complexity and cost. You'll see some of these in red, or some of these are red, some of these are green. The ones in green are ones that I'm not going to be able to solve with the issue that I'm going to suggest. The ones in red, I'm going to be able to solve. But complexity and cost sort of comes with the game here. Um, when you're talking about high level planning, and that's what this is. This is high level planning. I mean, really beyond what we're going to talk about today, you're looking at going offshore to the Cayman Islands or something like that. Cook Islands or Nevis is the hotbeds now. So this is pretty high level stuff, but you're doing it for a reason, to avoid significant estate taxes. And usually it's worth it, but it does come with complexity and cost, right? There will be a structure that needs to be maintained. It's going to cost you to get it set up by me or some other blood sucking lawyer, and you're going to have to manage it. And there's going to be additional tax returns and so forth that you didn't have to file if you just kept everything in your personal name. So complexity and cost is one thing I'm not going to be able to eliminate. Hopefully, you'll see though we'll be able to reduce it.
And Andrew, just to speak to that for a brief minute, I think a lot of times when we're talking to somebody about their legal planning, one of the primary concerns that comes up is that they want simplicity. And I mean, rightfully so, because our human mind can only grapple with so much complexity, and we don't want to necessarily step into the complexity, but also we don't want to layer complexity on the coming generations just for the sake of maintaining that and allowing it to be able to extend. But I think you're really bringing out the most important piece here, and it is to understand what are we actually accomplishing. And there will always be a necessary level of complexity to something that maybe is a complex situation that you are trying to resolve. But I think what you're saying is don't let it be needless complexity. Let it be really purposeful if it is accomplishing the right end goal. And that should be the main question, not how simple or complex it is.
Yeah, I mean, in my mind, my goal and I have a really complex structure, but that's because I get free legal work, right? So I always tell people I'm the Bentley dealer and I can drive any car on the lot, even if I personally couldn't afford it. So I have a really complex structure, but I'm trying to solve a huge issue for me, something that I'm very, very passionate about, right? We've written a couple books on it. I want a legacy. I don't want all of my hard work to be squandered. I mean, I think that this is a generational shift in how people are saying we want purpose behind what we're leaving, this $90 trillion that's going to pass from one generation to the next, if we take the time to really put some effort into it. So, yeah, without question, complexity and cost comes there. But if you can create a family legacy that can go on for many generations to come, is it worth it? And the
Mhm.
other thing is this is it's a job of finding the sweet spot, right? I can get somebody as complex as they possibly want to be and just want to make them pull their hair out. To me, it makes sense, but they don't want to actually run it that way. And the client is always in the driver's seat. I've got to, how much are you willing to deal with? Complexity and cost, and if I can get you to a point where you still feel comfortable, which I think I'm pretty good at getting a client to the point where, look, you understand this now. Yeah, you got some more entities involved, you got some more tax returns involved, but after the first year, that becomes kind of a well-oiled machine, right? You meet with your attorney and your CPA a couple times a year. You make sure that the things are being maintained, and you know where to pull money from the bank account because you've got that all instructed. So complexity and cost is something that we can get over. It really is the client determining where they want to kind of be on that spectrum.
I appreciate that.
Irreversibility of decisions. I hate that. I never like getting into something that I can't get out of because I don't have a crystal ball. I have no idea what's going to happen with the tax code. And anybody out there that says they do is lying.
Mhm.
Nobody knows. And I mean, Barron Trump could get elected president. He raises the estate tax limit, the amount you could pass tax free, to $1 billion. Well, we probably didn't need all of this stuff. So how can we actually get out of it? So I like being able to have some flexibility there. Tax complications, I'm going to eliminate that. And you'll see how, not to a fullest extent, but I actually like the additional tax returns that are coming into play here. That's where we can do a lot of the more creative accounting, if you will, within a family. Not anything tax abusive by any stretch of the imagine, but paying kids and all of these various things that are great things that you can potentially do. Administrative burden, that's the green one. You're going to have to maintain this. You're going to have to make sure that you're running it the right way. Otherwise, it's all going to be destroyed, right? Our enemies are going to be able to destroy it, enemy IRS. But also, in how we set these up, we really make it creditor protection as well. Limited flexibility, give tax consequences, the 3-year rule. I'm happy to go into those if you guys would like me to. And then the potential for mismanagement. Now, that's also one I can't solve. That goes back to, hey, how are you preparing your family, right? That's our second principle in our book, Entrusted, that entrusted families prepare the family for the wealth, not just the wealth for the family. And so many people are just concentrating on that wealth and how they're bundling it up and dumping onto their kids without the consequences. So that's to me the negatives, which are big negatives, and how do we get around it? Let me stop there. Questions, comments, anything I could expand on? I usually talk in paragraphs anyway.
No, this is really good. I like that you are being honest about all of the challenges, but also the things that are not eliminatable by a different structure. I really love that you are highlighting that key component of the potential for mismanagement and that it really depends on how well you've trained your children, how well you've transferred stewardship, how well you've equipped them, and what their character development is like so that they can do what's right with the wealth. So, Bruce, do you have anything on this?
No, I'm just going to say you can. We don't have to elaborate on the 3-year rule. It's that look back rule. Um, we don't have to, especially because we're going to look at other strategies besides this.
So eliminate that for sure.
Yeah.
Yeah. I'm trying to. I was going to tell you a story, but I think in the interest of time, we'll move on. All right. So this is kind of the typical islet structure that I'll see if I see an islet involved. And this is even in a sophisticated structure, right? In this case, we've got John and Jane Doe here. They've got, let's say, 4 kids, and they're fairly wealthy, so they got an islet, right? It's just standing alone off to the side. They can't be the trustees of it, or it'll be included in their estate, all of those bad things. And it's just sitting there to own that policy. Now, what do they buy the policy for? Like I said earlier, I still people just buy the policy to cover the estate tax liability, whatever that might be. Now, again, that would have to be about a $40 million estate at this point in time, right? If you calculate 28 million coming off the top, the remaining amount being subject to an estate tax, that wouldn't even get to the $10 million amount. The problem with that, though, is that when mom and dad dies, you've got their family LLC that owns their investment properties, their second home, and maybe an LLC that owns their cash and brokerage accounts and some of the things that I know you guys have seen me like to do. but it's all disheveled, right? We've got this big islet out there when mom and dad die that's got 10 million in assets. We've got all of the family assets being over here. It's not coordinated in any kind of way. I hate that, right? I really like, to me, that's way more complexity to a client than what I'm going to suggest, where there's just really one family partnership. The story, it's a good story. So when I meet with clients, I still have clients that will come in and say, Andrew, I'm just going to give it all to my kids at my death. If they blow it, so be it. I'm dead. I don't care. I also have the client that says, I'm not going to give my kid anything because they didn't earn it. I'm going to give it to charity.
Hmm.
I guess
We've
if
heard it
out of
all. Yeah.
those, yeah, but out of those two extremes, I side with the guy that's going to give it all to the kids, because at least in my mind, they're confident that their kids aren't gonna use it, right, or abuse it, right? They're saying, hey, look, I hopefully I've got good kids. They're gonna make the guy that says I'm not gonna give it to the kids because they didn't earn it. I'm gonna give it to charity. The charity didn't earn it either. It never made any sense to me. So I still like those kind of. Now, again, most of the people are saying there's a middle ground, and you guys obviously preach this as well, where you keep the money together and you avoid those erosive effects. So this is sort of the typical structure that I see. Obviously, where John and Jane here, they're still totally in charge of this side. They're not in charge of this side, right? We've talked about all of those negatives. So this is how I solve it. Okay. And like I said, this is pretty similar to what I have in my own structure. Um, Not an islet. What we put in here instead is a SLAT, or a domestic asset protection trust. Okay. We love these acronyms. Now, all that stands for here is a spousal lifetime access trust that also qualifies as a domestic asset protection trust. Okay. We use this in place of an islet. I love to form these in a state like Nevada, because Nevada has very, very protective asset protection trust laws. They also have fabulous decanting statutes. Decanting is a big thing in a trust where you have an irrevocable trust that you don't like any longer. Well, what you can do is you can take all of the assets out of the one trust and decant it into a new one. And
Hmm.
some states have decanting statutes, other states don't. And Nevada has a fabulous one. And so, in fact, I said I've never done a new islet in 12 years. I've worked on them, but usually it's been decanting an islet from one structure to another. And it's a
Okay.
big, it's kind of a pain to do, but you can do it. But I like Nevada for that reason. Now, let's take a step back. What the heck is a trust in general? Remember what a trust is. I don't care if we're talking about an islet, a slat, a DAPT, an irrevocable, whatever, land trust. Doesn't matter to me. A trust to me is three people involved in an agreement. That's it. It's a contract. It's an agreement. The first one being the creator of it. And we call that the grantor of the trust. So in this case, you guys will see that we've got John here as the grantor of the trust. He's creating it. And he's doing it by giving assets to the second player here, who's the trustee. And the trustee of the trust is the one that's in control of the trust and its assets and has the obligation to manage and protect the assets for the benefit of the beneficiaries, who in this case is Jane and the kids. John could theoretically be a beneficiary if we ever wanted him to be. There's some loops to go through, and we never need him to be unless he and Jane aren't married, right? Jane runs off to the Bahamas with the pool boy. He wants to be a beneficiary of the trust, and we got bigger problems going on at that point in time. But as long as they aren't married, or excuse me, as long as he's not a beneficiary of the trust and they are married, then him not being a beneficiary of the trust to me is greater protection from our enemies, right? Enemy number one, right, that came out was the IRS. And the IRS would love to say that the assets that are in this trust are part of John's estate. As I know, he's not even a beneficiary of the trust. How could you put part of his estate? And then the other creditor, or the other enemy, or creditors, right? Again, this will be an asset protection trust in Nevada. So we've got that protection. But if I also have the protection of John not being a beneficiary, that's even another layer that somebody couldn't go after. I mean, if somebody sued me for malpractice and I'm not even the beneficiary of some trust, how can they go after that asset? So greater protection. And then we put in a fourth player here that's called the trust protector. And we do that because of the glaring issue, which is also an issue in the island. John and Jane cannot be the trustees of the trust here in order for us to get the benefit that we want, moving out of the estate and beyond the reach of creditors. Okay. Same problem with the ILIT. So why is this any better? Give me a second. So first of all, because it can't be John and Jane, what we do is we divide the trustee position into three different types of trustees. Okay. Investment trustee, distribution trustee, qualified trustee. Let's take the qualified trustee first. I'll get rid of that one first. If we do this trust as a Nevada trust or a South Dakota trust or a Delaware trust, right? Any of these states that you hear people doing these asset protection trusts in, you need to use a trustee that is a resident of that state. So a Nevada resident who's over the age of 18 that's not a beneficiary of the trust, or you can hire a qualified trust company within that state. I
Mhm.
use one out of Las Vegas. They charge $950 a year to play that role as trustee, qualified trustee. What do? Not a whole lot. Two things really fundamentally. Number one, the trust itself is going to open a bank account in Nevada. Now, it can open bank accounts all over the world, but it's going to have at least one in Nevada. And I'd tell a client to put some money there, put $10,000 there and forget about it. And you can always get it back if you want because Jane's the beneficiary of the estate. But what that's doing is it's showing that the trust in Nevada actually has assets in Nevada. It's creating connection, or in the legal world, we call nexus. So that's an important thing. And the qualified trustee will be in charge of that account. The other trustees are going to be in charge of all of the bigger accounts all over the world. And we'll get back to that one just a minute. The other thing that the trustee is going to do, the qualified trustee will do, is they will sign the tax return for the trust. They won't prepare the return. The client's accountant will still prepare it, but they'll sign it. And that's basically it. So that's all they do. So the other trustees are far more important, the investment trustee and the distribution trustee. And as those names might foreshadow, the investment trustee is in charge of the investments of the trust, and the distribution trustee is in charge of the distributions coming out of the trust. They don't have to be different people. They don't have to be Nevada residents. They just can't be John, Jane, or any beneficiary of the estate. In my case, for my trust, my dynasty trust, it's my best friend, Corey. Corey and I, we've been best friends since we were 11 years old. I can call him up. He'll probably do what I ask him to do. And that's what you want here. You want a Corey, right? But he's had to deal with me for the last 38, almost 39 years now. And I'm not the easiest person to deal with, as my wife would tell you. So what if I called Corey and he didn't pick up the phone? I ticked him off for some reason. Well, that's where the fourth player comes in here, the trust protector. The trust protector has some important powers, but the biggest one is that they can fire a trustee and hire a new one. In my case, my trust protector is my law partner, David York, who I trust almost as much as I trust Corey. And so what happens now is if Candace, my wife, who's really the beneficiary here, calls Corey and says, "Hey, give me some money. You're the distribution trustee." And Corey says, "No." Well, her next call is going to be to my partner, David. And she's going to say, "David, fire Corey and hire a new trustee that's going to write me the check." Well, what if David says no? "Oh, Candace, I'm sorry. Andrew got to us as well. I can't write you the check." Well, her next call is going to be to me, or the grantor of the trust, and say, "Look, buddy, if you want to get in the house tonight, you don't want me to change the locks on you. You're going to fire that trust protector, that SOB law partner of yours. Hire a new trust protector that will then fire that SOB best friend of yours and hire a new distribution trustee that's going to send the money." So that's how we built in flexibility within a trust like this that you don't have in an ILIT. You can build that into an ILIT, but I don't see many people doing those in ILITs that way. Furthermore, as you'll see, I'm not even having to call Corey if I want to do something with any of my investments, with my life insurance policy. If I want to borrow from my policy, I have all of the right to do that. Okay. So you'll see how that comes in.
Okay, so let me
All
just
right.
ask a few clarifying questions. You've covered a
Yeah, please.
whole lot right there. So,
Yeah, I
so I
did. And quickly.
believe I believe that your wife is listed as a beneficiary, which was what allowed her to do that, or not?
My wife is absolutely a beneficiary of the trust. Yep.
Okay. And the reason you're able to access that slat or DAPT trust is because you're the grantor or because you're also a beneficiary?
Because I'm her husband and hopefully she'll treat me nicely. And
Okay, got it.
if
Okay.
I'm not her husband any longer, then I can become a beneficiary.
Okay, but you're only the grantor, and she's only the beneficiary. She's not also a grantor, and you're not also a beneficiary.
Exactly. That's why it's called a SLAT, Spousal Lifetime Access Trust. I create it for the benefit of my spouse for the rest of her life.
Got it.
Great questions. Okay, guys. So let me bring this all back. I just wanted to explain how this trust was different than the ILIT. It's still irrevocable. Okay, absolutely, like the ILIT is. And we talked about that being one of the negatives, the irreversibility of it, right? Hard word to say, at least for me. But this is the same. It is irrevocable. Now, I don't want to go into how this is all structured. The percentage that the islet or the adapt here winds up owning of the family company doesn't just get given, it gets sold, and you take back kind of a security interest. So if we wanted to unwind it, we could. That's a whole different discussion for another game. But also doing it in a state like Nevada, like we talked about, if it's irrevocable, if push comes to shove, we can decant it into a new irrevocable trust as well.
Got it.
Um,
So even though it's irrevocable, you can decant it because of that provision.
exactly. You always, when you're creating a trust like this, even an irrevocable trust, do it in a state that has a good decanting statute. Even if you use a very traditional islet, which again, I urge you not to, but if you do, do it in a state that has a good decanting statute.
Awesome.
We joke about the I joke, I probably made a joke earlier, right, about how strong the lobby is with the insurance companies and that they get what they want. And it really is the case. But with a swipe of a pen, life insurance could become a completely different ball game and not have the same tax benefits. And maybe the islet isn't a good thing to do anyway. Maybe you say, hey, look, Andrew, I'm going to earmark that. That's going to pay the death taxes. I want to use it in a traditional standpoint. I don't want what you're talking about, fine, but you still ought to be able to change it and definitely work with a decanting state. Um,
Interesting. Okay.
okay, so now let's go back. Remember the erosive effects, division of the estate taxes, creditors taking the assets, and the misuse of the assets by the beneficiaries. Okay. So how does this structure solve the problem? Because I want to make sure you guys have time to ask questions and so forth, and I want to be sensitive of your time. Well, first of all, let's say you have a husband and wife, $100 million in assets, and they have four kids who have four kids who have four kids, right? That whole scenario that we talked about before. Well, in this case, really, it would be the holding company that has the 100 million. Okay. Now, when something happens to mom and dad, what I do, and you guys know this, since I've done it, Rachel, for your trust planning, is that I never leave anything outright to kids. Nothing goes outright to kids. I pass away, my kids don't get anything outright. They get a trust for their benefit, right? Through the trust documents. And this happens both in the revocable trust that everybody ought to have, as well as these irrevocable trusts. It ought to say that nothing goes outright to your kids ever. I don't care how responsible your kids are. Tell me your son is smarter than Warren Buffett. I would still say don't leave it to him outright. Leave it in a trust for their benefit. Why? Three reasons, really, two objective ones, one that's sort of more subjective. Number one, by leaving it to them outright, you make it part of their estate for their estate tax purposes. And that's just not wise. Usually, these high net worth families, they have multiple generations of wealth. And yeah, mom and dad are wealthy, kids are wealthy, grandkids are wealthy. Why do you want to keep loading it up subject to that haircut as every generation? By leaving it in trust for their benefit, you can generationally skip it from estate taxes. It's what's called the GST exemption. Whole another hour that I would bore everybody to death with on it, but it's a really important thing so that as my mom passes, she doesn't leave anything that is going to add to my estate tax problem. Right. I hit the Powerball. I'm worth $1 billion. I don't need my mom giving me more assets that are going to be included in my estate. By leaving it in a trust for my lifetime, I'm the beneficiary. It's there for health, education, maintenance, support, family purpose, legacy planning, all of those things it's there for, but the assets are not mine. Second objective reason is you make it unavailable to bad actors, right? I have three kids. My youngest is my daughter. I don't know who can ever come into her life that's going to be good enough to marry her. I'm hoping somebody is,
How old
but
did you say she was?
she's 15.
Yeah, I feel you.
If you ask dad, she's 15. If you ask her, she's 35. But
Yep.
the thought of her, it just brings me nightmares. But if she finds a guy that's good enough, I don't hold a shotgun to, and they get married, there's a 49% chance that their marriage will make it. There's a better than odds chance it's not going to make it. And you have four kids. Well, two of them are going to get divorced at least. I don't want the assets going to the kids, because then what they do is they take the money, they commingle it with marital funds, and it gets wrapped up in a divorce. And then also it'll be taken by a creditor. They get in a lawsuit, they start a business and it fails and go through a bankruptcy. Well, if you just say, here you go at death, here's your share of the estate, that becomes their asset and their creditors are going to take it. By leaving it in a trust for their benefit, it never becomes available to the creditors, right? So we're protecting against that third erosive effect. Now, what we're also doing is we're not dividing anything. Something happens to my wife and myself. Well, nothing goes out to our kids, right? Each of our kids become an owner, their lifetime trust own 1/3 of our family holding company. The 100 million is still there. And yeah, Thomas has a trust with a 1/3 interest in it. Madeline has a 1/3 interest. Harrison has a 1/3 interest. But the 100 million is still there at work. It didn't get broken up. So no division of the estate, right? Solve that issue. The way that I have my structure is right now, 98% of my family holding company is actually owned by that asset protection trust. So that means something happens to us, what's included in our estate? Well, I guess the 1% that is owned in our revocable trusts, but 98 million is not part of our estate for estate tax purposes. It's out of the estate for estate tax purposes, right? So we solve that issue. The third issue, again, the creditor we talked about, my kids don't get anything, get a trust for their benefit that will own the holding company, managed by a board of trustees for their benefit until they become wiser and able to manage it themselves. But going back to the flexibility here, where is all the day-to-day operations going on? It is handled all underneath the holding company, right? The holding company owns everything. They own an investment property, they own the second home. They've got the family bank, or what I refer to as the family vault. In there is all their cash, all the insurance, right? My insurance, my wife's insurance, the insurance on all of our kids is owned in our family bank. Something now happens to me, and I have a lot of death benefit on my life. I think it's over 20 million right now. If something happens to me, $20 million will go into this LLC. Okay. 98% of it not part of the estate. My wife is the manager of that LLC after I die. We're both managers while we are. She still can do whatever she wants with that $20 million, but it's not part of the estate. So that's where that all sits in our overall structure. Get benefit of the ILIT, or the negatives of the ILIT are all gone. I want to borrow from my life insurance policy, let's say. Well, I'm the manager of the LLC. I go to the insurance company. I say, look, this LLC, which owns the policy, wants to borrow $1 million. Give me a check, or give the LLC a check. So I have full authority to do that. I have not once called my trustee. I never told Corey anything. The only time Corey would need to know anything is if money was coming out of the system. Why would that happen? Well, it would only happen really if I didn't take it out another way, and there's a myriad of other ways I could take it out. But it would also be if I wanted to spend it, or really my wife wanted to spend it. She decides that she wants to take the whole family on a trip to Africa and do a safari. I have this family doing it. They're paying $300,000 for this safari, if you can imagine. And I say, okay, if we're going to take $300,000 out to go do that, well, she can do it, right? We're the managers of the LLC. So we take the 300,000 that's there, we borrow from our insurance policies, we give it to the family holding company, and it goes to the trust. And now the trusts don't have to have business purposes. They can pay for family vacations. In fact, they're required to for the benefit of the beneficiaries. So we go on our trip that way. That's one way that we're going to go spend it. But if we were going to buy a new asset, right now we have a place up in Montana, and just next to us, there's 30 acres that I would love to buy because I don't want anybody to ever build there. Um, I'm not Bill Gates. It's only 30 acres, okay? But I don't want the cabin there. And I'm gonna have to wait to buy it because the woman who owns it, we've been up here for 27 years now. And if you're from Utah and Montana, you're no better than if you're from California. So they're just barely warming up to us here in Montana. And I think I'm gonna have to wait until she passes away because her kids don't want the property. But I think I'll need about 500,000 to go buy that property. Well, this is what I would do. And this is, again, keep in mind, me doing it. I have not talked to Corey. I haven't talked to anybody else other than, of course, my wife. But if I had my family bank that had the 500K, I could take the money. I could give it to the holding company. The holding company could put it into some LLC in Montana, and now we go buy the property. But what I've done is I have taken the 500,000 of cash or really well protected cash value in an insurance policy, and I've exposed it, right? Rachel, Bruce, I invite you guys up here. You slip and fall on the property, there's an additional amount of equity at risk. So when people talk about family bank, I don't think that they really, I mean, not you guys, but I hear people talking about it all the time. I'm like, do you really use it the way that you're preaching? I use it as a bank, right? If my family bank has the 500K, I'm going to borrow it. I'm going to have the company that needs it take a loan from the company and give back a mortgage. Now I haven't moved any equity. You guys come on fall on the property, there is an additional 500,000 at risk. But I'm doing all of that underneath the LLC, never once having to deal with the trustee. So that's where, my snippy comment, hey, there's a better way. There's definitely a better way. That's a lot.
Yeah, that
Questions, because
is.
I'd love to go over. I just threw out a semester's worth of information, but whatever you want to feather out, as you know, I'm happy to come back and give more info.
Go ahead, Bruce.
So you're saying that you would set up an agreement with the insurance that you're paying it back just like you would a mortgage, and that gives you protection.
Yeah, it's called equity stripping, and it actually has a really bad name in this world of asset protection because nobody does it. They don't do it the right way. And what I mean by that is they'll hear some Yahoo like me talk about it, and they'll say, "I bought a property a couple of years ago. Can I suck the equity out of it now?" No, it's after the matter flat planning. It just doesn't work. It burns down. But if you do it right from the get-go, it absolutely works. Right? I get the opportunity to buy this property, and I'm taking that money from the family bank. Well, in how we run our family, we have a moral obligation to take it as a loan. My kids don't get anything. They have to take loans. I encourage entrepreneurialism. It's a big thing in my life. Yes, I'm a blood-sucking lawyer, but we also started our firm. We have our company Corenology. It's been fun to build companies. I like that. I want to encourage it. But my kids aren't just going to given money to go start a business. They can borrow it. But before they borrow it, they're going to have to do a couple more things. They're going to have to create a business plan. And what if my wife and I aren't there, right? We pass away, they're still going to have to do it. Now they're
Mhm.
going to have to present the business plan to our board of trustees that is now running all of this thing. And they're going to help my kids to develop the best business plan possible. But my kids are also going to be held accountable, right? They took a loan from our family bank. They need to come back and tell what's gone on with that loan. What did they do right with it? What did they do wrong with it? Can they do business together? I want my family doing business together. What an amazing legacy that could actually be if they're all in business together and they're coming up with new ideas. I know they're going to make failures. We all made mistakes in our lives. I've lost a lot of money making stupid mistakes, but I don't want all three of my kids making the same mistake. So then coming back every year when we do our potato sack family reunion, we spend a whole day talking about family business. And one of those is what are the outstanding loans and what's happening with it? Oh, it's gone. I made a mistake. All right, what did you do wrong? How are you held accountable for that? So it's a whole different way to think about it. But if I expect that of my kids, don't I expect that of myself? So look, I take $500,000 loan from our family bank. It's absolutely a loan. I'm not just going to pump it in as equity into the property and put it at risk.
Great. So you, this is maybe for another time, but uh, so I'll just briefly touch on it. So what if the kids do have a failed business? Uh, Are you going to have them pay back that loan through properly structured life insurance policy? So upon their death, it gets paid back? Or I know we've structured some of them that, let's say they're getting $100,000 distribution out of the trust every year, that there are provisions in there. If you haven't paid back your loan, then whatever you want to take out of that distribution to then repay the loan, uh, could also be another provision that you could put into the.
Yeah, and I see it all over the board. You're kind of that second one was the what we call kind of an equalization provision, and we see it all the time. I know each of my kids are going to take more or less expensive paths, right? My second son wants to be an NHL player, and he's good. Luckily, he got his mom's athletic abilities, not mine. And he's AAA. We're traveling all over the country. We're going to camps. We're spending a lot of money to do that. And my oldest son, he's in college. I'm helping him with tuition. My daughter, she likes to dance. We were in New York at a dance academy. So they're each taking their own life paths. And I'm just sort of willing to absorb this idea of equality of opportunity as opposed to equality of outcome, right? I
Mhm.
give them all the same equality to do what they want, but the life path they choose, they need to accept the consequences from it. And look, he makes the NHL and he's getting $12 million dollars a year. Well, great. Good for him. He worked hard at it, though. He's up at 6 morning at the ice, whatever it might be. So to me, it's sort of what they're doing with their opportunity. That includes the business loan, Bruce, to I don't actually directly answer your question. I think it will depend. If a child comes to me with good intentions and says, look, I want to borrow from the family bank to go open a lemonade stand. Okay, I don't. Let's whatever. I said, great. Okay, come up with the business plan. Here's the loan. I'm going to loan you some money to go do that. Let's say nobody drives by and gets his lemonade and he goes bankrupt. But he was out there all day. He was working hard. He put good effort to it. He made good lemonade. It's just nobody would buy it. Well, great. I mean, what did you learn from that? I think there was good intentions there. He's still going to have to come back and say, look, I lost the money. And they're going to say, why? Nobody bought the lemonade. All right. Where was your lemonade stand? Let's try to turn it into a learning lesson. So to me, if there's good intentions behind that, I might forgive him. I might say, look, lick your wounds. We'll move on. But if he makes crappy lemonade, he leaves after an hour because he doesn't like being out in the sun, right? And he wastes all the money. That's a whole different story. So how that business of family, we have a whole nother presentation on the business of family comes into play. Really depends upon how you want to run your business now or run your family. Now, the equalization is probably the most common that I see where you have say a family that's frustrated, and that's usually where it's coming from, a point of frustration. I have a client right now whose son's gotten into some criminal issues and they're having to spend a lot of money to keep him out of jail. My thought process is let him go to jail and learn his lesson, but they're putting a lot of money to keep him out of jail to the tune of, I think, over $500,000 in criminal defense fees. It's a wealthy family, but they're saying, look, you've blown through 500,000 of your inheritance. And when something happens to mom and dad, you're getting half that much. But that's not a business. That's right. He got in trouble doing stuff he shouldn't have been doing. So again, you get the lawyer answer. It kind of
Yeah,
depends.
yeah, yeah. Great. And then
So go ahead,
the
Bruce.
other question I had is a simple one. So how, and I don't know the legal term for this, but how long will this LLC in Wyoming last, or any of the subsidiary LLCs, and how long will the Dynasty Trust last?
So it's the LLC isn't the concern because that can, even when it comes up, I think it's 99 years in Wyoming. I'd have to go back and look. I mean, it's still a long time, but when that does come up, it can still get renewed. So that can kind of perpetually go on. The trust, I think what you're referring to there, Bruce, in fact, I know it is, right, is the rule against perpetuities, where certain states say that trust can only last for so long. Nevada says 365 years that it can go on. I don't,
Okay.
how many are 7 generations? I think that
It's
covers seven
about 200.
generations.
It does.
Yeah,
I mean,
it covers.
What's funny is South, I don't know what's funny. I think it's funny, but this is one of the many reasons that my wife thinks I'm boring. South Dakota, they have a 999-year statute. So it can go on for almost 1,000 years. And there's been this big move of money from China going into these South Dakota trusts because they want to create 1,000-year dynasties. So they can go on a long time.
Wow. Actually, that was the nature of one of my questions as well. So, you mentioned shared interest, or in your case with three kids, one third, one third, one third shared interest at the holding company level. So let's just extend that out to your example that you had. Parents who have four kids, who have four kids, who have four kids, that's 64 great great grandchildren. So would you end up with a holding company that has, I don't even know what percentage that would be, but it's probably around, I mean, 1.6% or something interest across 64 great great grandchildren? Like, what would that end up looking like? And the nature of my question is, does that limit one person's access to the capital to that narrow slice and not more than that amount?
Um, okay. You asked the first question. I was looking for a slide that I couldn't find to kind of illustrate
Sorry.
it. Ask it one more time. I apologize.
So when you have children who have children who have children, where does
Oh, the
that,
the diffusion. Yes.
yeah,
And
so if you're keeping it all together, does the shared interest in the holding company, maybe that's not a third, a third, a third anymore. Now you're down to four kids who have four kids who have four kids. What does that shared interest look like? And is that like 1% each or something like that?
just like every other wealthy family, right? If you think about, let's think about the Rothschilds. Okay, people say the Rockefellers, they do this as well, but their companies own all of the assets. It's just all of the kids own a share of it. And it what gets diffused through the ownership interest. So where it would be one third in my case, let's say that now Thomas, my oldest, has three kids of his own. All right, they're each now going to own 1/6 of that
Hmm.
LLC, and we go along. And now there are other ways to do this. There are clients of mine that rather than that diffused ownership, what they will do is they will keep it all together in a pot trust. Okay. Now, let me make clear what a pot trust is because of these relaxing laws around the country. This is not a trust that somebody gets to roll up and smoke. This is a trust that is an entire pot for all of the beneficiaries. So, you know, kids are beneficiaries of it, grandkids as they come on the scene, great grandkids as they come on the scene. They're all beneficiaries of the same trust owning the assets. It's definitely one way to look at it. I have a lot of clients that like that. What I'm trying to do with my structure is again this equality of opportunity versus equality of outcome.
Hmm.
I want my kids to be able to have as many kids as they want, right? And one might have four, one might have two. Do I treat grandkids all the same? I don't know. I've said no. I've said, look, if your dad has four kids, you're going to get less interest in the company. And as a family, you just need to deal with that because that's the way that I've dealt with it in my structure. But you can do it a different way. You can do it where every generational group is treated to the same degree. That's probably more the Rothschild model than the Rockefeller model.
Got it. And that's really helpful. So if you were in the more pot structure where every generational level is treated to the same degree, then all great grandchildren would be equal, regardless of whether they were an only child or their parents, they were one of 12 kids, is what you're saying.
Yep, exactly
And
right.
and then in that situation, if you're under either environment, let's just say I am the great great grandchild and I have a, 1/32nd percentage or whatever. Does that mean that in terms of accessing the whole trust capital, I cannot access more than that for loans or things that I would that my endeavors would
But
be, and each individual person stays within that confine?
a really, really, really great question. So, and I think I can highlight it even with what's on the screen. So let's say that John's trust here owns 1% of the LLC. Jane's trust owns 1% of the LLC. and the slat owns 98%. Okay. So we have multiple beneficiaries already, or multiple owners, right? We can diffuse it out however far we want. But the fact is, this is being taxed as a partnership. Okay. The company that owns all of the assets. And partnerships are pretty flexible when it comes to distributions. It says you can pay one partner and not another, and you have done nothing wrong. So even though John might only own 1%, the LLC could still give him more of the money. You can make
Mm.
disproportionate distributions. So, like with our family plan, we have a 50-page document, our core knowledge report that talks about the core values of each member and the family in general. And we leave a lot of discretion up to that board to say in the moment, because don't have a crystal ball. I don't know if insurance is going to be a good product in the future. Swipe of the pen, it's not going to be. But I can say, look, I like the idea of the family banking concept. I like the idea of getting insurance on kids so that they're insurable. I like the idea of bringing cash value into it. But if there's something better in the future to do those same things, then I'm going to give you the discretion at the time to be able to make those decisions. You're setting purpose. My purpose with having that life insurance is to, quite honestly, as callous as it sounds, to replenish the economic loss that our family has suffered through the loss of losing that child. I mean, I spent a lot of money on my kids, and I expect them to come in and be the stewards over that next legacy that I'm going to leave them. And I'm putting a lot of investment in them with that hope. And if I lose, God forbid, one of my kids, knock on wood, not only am I going to be emotionally devastated, of course, but if we have inflow of money coming back in to help perpetuate the economic loss, it might be callous in how you look at it. But I think looking at my kids as an asset is actually not callous at all.
Yeah, absolutely. People are the
I'm
greatest
preaching to the
asset.
choir.
You
I'm
are.
preaching to the
You
choir.
are. This is good. I know we're out of time. You go ahead and wrap where you were planning to today. This has been really helpful.
That's it. That's how I solve this issue. That's the structure that I implement myself in terms of the goals here. It's out of the estate for estate taxes. I still have a lot of control over what's going on with that money, what's happening with it. We have the ability to pull it out. Yes, there is complexity. We've got to have that partnership tax return. I love partnership tax returns. That's where, I pay kids and do a lot of our more creative accounting. Because then what I get at the end of the year is simply a K-1 from the accountant, and I have to report a number on my personal tax return. So I like that. The partnership, you can do a lot of flexibility. Again, it gives you great protection. So to me, that's the way to solve it. And I still like irrevocable trust for the purposes of moving it out of the estate. But with the slat strategy, it's just much more protective and flexible. Look at that,
That's
cutie.
awesome. That's awesome. This has been really helpful today. And I think especially for somebody who is really asking the question of not only how do I save tax, how do I minimize estate taxes, but how do I create that opportunity for stewardship for my children. So a lot of the work that we do that you are aware of and that you're so aligned with is that providing guidance to the next generation. But the guidance can only do what the trust structures allow. And what you're talking about is the trust structure that can most effectively accomplish all of these objectives, not just minimizing the estate tax. Because I mean, the challenge is if you're just making financial decisions based on the math, based on what is going to be fiscally the most constructive and have the least loss, you can prevent the family from actually having access to the capital and the control to be able to flourish the way that that you want by the plans that you're putting in place in the first place.
100%. Yeah, you can have the benefit of both worlds. A trust with no assets inside of it is worthless. And, I bet 90% of the time when I'm reviewing a trust that somebody brings to me, another planner had done, I'll see in there that they'll hold it in trust if they die for their kids until they get certain ages, 25, 30, 35, whatever it might be. but then the assets just get distributed out. So by the time there's 30, there's no money in the trust. And you can put 50-page documents in your trust that give ideas about what you would prefer legacy to be. I promise you, your great grandchildren aren't going to read it. But if the trust controls their money, they're going to read it and they're going to say, look, these are the core values of our family. And, the expectations are laid out. We say this a lot. Three expectations have to be made clear within families. They need to know what they can expect from being part of your family. There's got to be a benefit to it. Otherwise, why do they care? They need to know what not to expect. Right? Mom and dad are wealthy doesn't mean you don't have to work and become self-sufficient. And they need to know what's expected of them. Right? How are you plugging into the family in order to get that opportunity that we talked about earlier? And very few families lay those things out. Again, preaching to the choir, but a lot of this sort of forces that discussion. And then, as you know, our chronology process really fetters all that out as well. And in your 7 generational wealth, I love how you guys talk about that in your book too.
Yeah, this has been really helpful, Andrew. And thank you so much for just being willing to enter the discussion. And I love how much education you provide. It's amazing.
Probably
It's
too
it's
much.
fantastic.
Yeah, no. Yeah, somebody went to sleep probably 20 minutes ago, if not longer, but it's a lot. You guys have my contact info if your people want to reach out. I'm happy to talk to anybody. So you just let me know.
Absolutely. And if you do have questions for Andrew and you are interested in this planning process, if you're interested in really making sure that your money is going to do much more for generations to come, reach out to us, let us know, and we can be able to connect you and put you in touch with Andrew. So thank you so much for the conversation and enjoy your time up in Montana.
Thank you so much. Yeah, thanks for having me. I love being on your show because my wife pays me to not talk. So anybody's willing to listen to me, it's a pleasure.
That's awesome. Thank you
Take
so
care, you
much.
guys.
We appreciate it. And if you're listening, please remember success leaves clues. So model the successful few, not the crowd, and build a life and business you love. We'll see you next time.